appeal in the matter of Watts and HMRC.
Yes, Ms. Nathan.
I appear with my learned junior,
Yes.
Mr. Colin Kelly, and my learned friends, Mr. Jonathan David KC and Josh Carey, appear for His Majesty's Revenue and Customs. Just as a matter of housekeeping, I just wanted to check that you have a core bundle, a supplemental bundle, and 3 files making up
Yes.
the authorities bundle.
Yes.
I understand that there was some splitting up of one of the documents as between the authorities bundles 2 and 3, but I think that's been addressed. So I will. I'm working from hard copies. I will attempt to give you both the PDF as well as the tab number.
If it helps, I can
Yes.
tell you that we have read both tribunal decisions. We have read the skeleton arguments. We have read Berry, since it's one of your grounds of appeal. We have read UBS, and we have read Rossendale.
I'm very grateful for that indication, my lord. So we come before you because Mr. Watts, whom you see sitting behind me, and who was described by the FTT as a shrewd businessman with a sharp intellect and the chairman of a sizable and successful business, was persuaded by Grant Thornton to enter into arrangements which he was told would help the government raise funds to meet its expenditure. And this is recorded by the Upper Tribunal at paragraph 8. For your reference, that's at PDF 65 of the core bundle.
Sorry, which paragraph did you say?
Paragraph 8
8.
of the Upper Tribunal. And that's at tab 6 of the core bundle at PDF 65. This is a recording of facts not in dispute. Tab 6, PDF 63 is where the UT decision
Yes.
starts. And at page PDF 65, paragraph 7 starts, we set out below a summary of the facts found by the FTT. They are not in dispute. And then at 8, it says, the appellant was introduced to a partner in Grant Thornton who explained to him that the government was having difficulty selling sufficient gilts to cover its expenditure and marketed the appellant arrangements which involved the appellant purchasing gilt strips with borrowed money. And then at paragraph 10, just over the page, my lord, the appellant was also assured by Grant Thornton, and this is a recording, that this was legitimate tax planning.
Yes.
However, as matters transpired following HMRC's inquiries, Grant Thornton told Mr. Watts that the arrangements that he had entered into had a very low chance of success. And he was understandably dismayed, and all of this is set out in his witness statement, in particular paragraphs 107 and 108. The extent of his dismay is set out particularly in an email that is attached to paragraph 108. I won't
I
trouble
don't
the
know if it
court.
matters, but I have not read the witness statement.
Perhaps if I might just invite you to read paragraphs 107 and 108 to yourself for the moment, so that you can understand.
Right. That's in the supplementary bundle,
It
is it?
is in the supplementary bundle. It is at tab 9.
Yeah. 107 and 108, you said.
The pages are 102 and 103, paragraphs 107 and 108. They're
This
very
is
short.
Mr. Watts' witness
Yes.
statement. Yes.
And it's that last plea in the email. If the legislation under which gilt strips operated was not changed retrospectively, where did it all go wrong? And the appellant submits that the legislation, as it stood at the time he entered into the arrangements, does not prevent him from securing the loss relief set out in the legislation, properly construed. And the matter is one, we say, of statutory construction, and it's of the relevant legislation, paragraph 14A, schedule 13, FA 1996, as it stood at that time. And at the heart of the dispute between the parties is the correct application of the Ramsey principle. For the avoidance of doubt, this I say particularly because one of the arguments run in Berry was this, but it is not an argument here. It is no part of the appellant's case that the relevant legislation is immune from the Ramsey principle. Rather, the appellant's case is that if the Ramsey principle is applied in line with the guidance from the Supreme Court in cases such as BMBF and UBS, the legislation does not deny Mr. Watts his claimed loss relief. There are 4 points broadly that we need to address you on in order to make good our submissions. And these all flow, we say, from Ramsey as explained in UBS paragraph 68. And this is broadly the structure of my submissions today. First, the meaning of paragraph 14a, purposively construed. This is going to be where most of the heavy lifting is done, because I will need to take you through not just the language, but also the legislative history, as well as some of the extra statutory materials. And it's there also that I will address you on Berry and how it approached paragraph 14a. The second aspect will be what facts need to be taken into account in applying paragraph 14a when it is purposively construed. Third, having identified the facts that are relevant to the application of that paragraph, what is the outcome of the application of that paragraph to the facts? And then fourth, identifying the Upper Tribunal's and the FTT's errors. But as you will see, my lords, in taking you through the first 3 parts, I can deal with the last part quite quickly. In fact, the second and third parts can probably also be dealt with quite quickly. So I don't propose to take you through the summary facts, given your indication that you've read the decisions. The point to note is that the revenue do not, in this case, argue sham at all. So the transactions happened. They took they had the consequences that they had. The question is whether, as a result of the application of the Ramsey principle, Mr. Watts is entitled to his relief. Now, in Berry, my lord, you stated at paragraphs 51 and 52 certain propositions. If I might just take you to those so that we have those in mind as I make my submissions.
Yeah.
So that's to be found in the second bundle of authorities. Behind tab 22. And the relevant paragraphs are 51 and 52, and they're to be found at PDF 484. If I may summarize what is said there, it is that the purpose identified by the FTT of paragraph 14a is a person sustains a loss in the year of assessment from the discount on a strip shall be entitled to relief from income tax on the amount of his income for that year according to the amount of the loss. You said that the FTT were right to identify the purpose of the paragraph in that way. You stated that this is not a case in which Parliament had used algebra amount A and amount B to create a notional profit or loss. It had used words that had a recognised commercial meaning, and it is to be expected that Parliament intended to tax and relieve real commercial outcomes, and that this is precisely how the Ramsey principle is meant to operate. And the appellant contends with the greatest respect that this interpretation of the purpose and meaning of paragraph 14a is not consistent with the approach as identified by the Supreme Court, certainly at paragraph 68 of UBS. It finds echoes also in BMBF, and I'll take you to that, and also in paragraph 15 of Rossendale. So,
which was a paragraph of UBS? 58?
68, my
68.
lord. Yes. I will be going to that.
Yeah.
I'm not going to, so the first port of call really is the Ramsey principle, but I know, my lords, you'll all be very familiar with the Ramsey principle, so I'm not going to read you large tracts of the various decisions. I'm certainly not going to take you all the way back to the fountainhead. But there are a few passages from 3 or 4 cases that I'd like to take you to. The first of which is BMBF itself, which is to be found in tab 19 of this. For me, it's the second bundle.
Yep.
Of authorities. It starts at PDF 415, but if I might invite you to go to PDF 425, that's where the Ramsey principle, that's where the House of Lords starts dealing with the Ramsey principle there. If I could invite you to turn to paragraph 32, which is to be found at PDF 426. And there, I just want to pick out a few of these passages just to emphasize them. The essence of the new approach was to give the statutory provision a purpose of construction in order to determine the nature of the transaction to which it was intended to apply, and then to decide whether the actual transaction, which might involve considering the overall effect of a number of elements intended to operate together, answered the statutory description. And then towards the bottom of that paragraph, as Lord Nichols of Birkenhead said in McNiven and Westmoreland, the paramount question is always one of interpretation of the particular statutory provision and its application to the facts of the case. If I could just invite you to then turn to paragraph 36, which is towards the bottom of the next page. Cases such as these, because he went through Burma, oil, furnace, etc., cases such as these gave rise to the view that in the application of any taxing statute, transactions or elements of transactions which had no commercial purpose were to be disregarded, but that is going too far. And if I might then invite you to go to paragraph 37, the need to avoid sweeping generalizations about disregarding transactions undertaken for the purpose of tax avoidance is shown by McNiven and Westmoreland, in which the question was whether a payment of interest by a debtor who had borrowed the money for that purpose from the creditor himself and which had been made solely to reduce his liability to tax was a payment of interest within the meaning of the statute, which entitled him to a deduction or repayment of tax. And in the last sentence, as the payment was accepted to have this effect, it answered the statutory description, notwithstanding the circular nature of the payment and its tax avoidance purpose. Paragraph 38, McNiven shows that the need to focus carefully upon the statutory provision and to identify its requirements before one can decide whether circular payments or elements inserted for the purpose of tax avoidance should be disregarded or treated as irrelevant for the purposes of the statute. And then he addresses the commercial legal dichotomy that arose as a result of Lord Hoffman's speech in McNiven. And he states about towards the bottom of that paragraph, this is not an unreasonable generalization. Do you have that, my lord?
Yeah.
This is not an unreasonable generalization, indeed perhaps something of a truism, but we do not think that it was intended to provide a substitute for a close analysis of what that statute, what the statute means. So we see here that the court is saying purpose of construction, look at the particular statutory provision and understand what it is looking for. And the question of what it is looking for, we say, is made even clearer by the reference to McNiven, where one looks at what facts are relevant, and even in BMBF itself, when one looks at what facts are relevant for the particular statutory provision. And this point is made very clear, we say, in UBS, to which I would now like to take you. And that's to be found in the same bundle at tab 27. It starts at page 588, but if I might invite you to go to PDF 608, paragraph 64. It's the passage that starts secondly. Might I invite you to read that paragraph, my lord?
Yes. Yeah, this is about disregarding steps.
Exactly, my lord. But actually what it's talking about is how to look at the facts that are relevant for the purposes of the statute. So disregarding steps is a question of filtering out filtering out the facts that are relevant for the purposes of the statute and those that are irrelevant for the purposes of the statute. And what the court is recognising there is in carrying out that exercise, one has to look at what the scope of that particular statutory provision is, what it's trying to do, and then to see if the facts are relevant in order to determine whether or not the relief that it's supposed to give is in fact secured. And the point there is that following the citation from Arrowtown, where schemes involve intermediate transactions inserted for the sole purpose of tax avoidance, it's quite likely that a purpose of construction will result in the steps being disregarded for fiscal purposes, but not always. And this is a point that you, my lord, also picked up in Berry, that sometimes tax avoidance schemes work because the legislation applies to them regardless of the tax avoidance purpose. So at paragraph 65 in UBS, the passage to which I'd like to draw your particular attention is the one that starts just by G, but it all depends on the construction of the provision in question. Some enactments, properly construed, confer relief from taxation even where the transaction in question forms part of a wider arrangement undertaken solely for the purpose of obtaining the relief. The point is illustrated by McNiven and Barclays Mercantile itself. And then if I could invite you to go forward to paragraph 67, references to reality should not, however, be misunderstood. In the first place, the approach described in Barclays Mercantile and the earlier cases in this line of authority has nothing to do with the concept of sham. And then he quotes Magukian and says that tax avoidance is the spur to executing genuine documents and entering into genuine arrangements. This is not in point here because nobody's arguing sham in this case. Secondly, and this is the paragraph at 68, secondly, it might be said that transactions must always be viewed realistically if the alternative is to view them unrealistically. And this is the passage to which I'd particularly like to draw your attention, my lords. The point is that the facts must be analysed in the light of the statutory provision being applied. If a fact is of no relevance to the application of the statute, then it can be disregarded for that purpose. If, as in Ramsey, the relevant fact is the overall economic outcome of a series of commercially linked transactions, then that is the fact upon which it is necessary to focus. If, on the other hand, the legislation requires the court to focus on a specific transaction, as in McNiven and Barclays Mercantile, then other transactions, although related, are unlikely to have any bearing on its application. And so just to relate that to the relevant legislation to which I will come, we have here a piece of legislation that states loss from a discount on a strip. Relief is provided for loss from a discount on a strip. Paragraph 3 states that there is a loss from a discount on a strip where, and then sets out two requirements. The second, in subparagraph B, it has two inputs, and it says what the relationships are between the inputs. So the question to ask oneself is, we would submit, that do the amounts that are taken into account here form part of amounts payable on the transfer and amounts paid? And if they do, then those are the things you look at. You don't look at the wider transaction.
So what do you say is the purpose of paragraph 14A?
Exactly, my lord. And what I was going to take you to is the background to the legislation, but also the legislative history, to make good the fact that the purpose of the legislation is to give relief for the thing that is identified by paragraph 14A sub 3B, because that is what is the target of the relief under paragraph 14A1. The reason I say that is threefold. One, the language of the legislation. Two, the legislative history. And three, the background to why the legislation was put in place in the first place. So just before I get to that, though, if I might just point to one small passage in Rossendale, which we say also supports what paragraph 68 says in UBS as to the way in which one looks at the facts, taking into account the facts that are relevant for the purposes of that particular statute. And that is, Rossendale is to be found at tab 32, so it's in your third bundle of authorities. It's in the third folder of the bundle of authorities. At tab 32. Starts at page 845. And the passages to which I would like to take you, my lords, is at page 859, paragraphs 15 and 16. So page 859, paragraphs 15 and 16, you'll be very familiar with these. So in relation to paragraph 15, in the task of ascertaining whether a particular statutory provision imposes a charge or grants an exemption from charge, the Ramsey approach is generally described, as it is in the statements quoted above, as involving two components or stages. The first is to ascertain the class of facts, which may or may not be transactions, intended to be affected by the charge or exemption. This is the process of interpretation of the statutory provision in the light of its purpose. The second is to discover whether the relevant facts fall within that class in the sense that they answer to the statutory description. This may be described as a process of application of the statutory provision to the facts. We say that the passage that states the first is to ascertain the class of facts intended to be affected by the charge or exemption echoes the view of the facts and the taking account of the facts that are relevant for the statutory provision that is identified at paragraph 68 of UBS. There are a few other general points I'd like to make before I take you to the legislative background, history, etc. And the first of those is that the Ramsey principle does not necessarily mean that transactions are disregarded if they form part of a series of transactions. It depends on the statutory language. Nor does Ramsey always mean that all the steps in a transaction must be seen together. Again, it depends on what the statute is looking at. It's the statutory gaze that is relevant. And examples of this are Westmoreland and McNiven, where despite the fact that it was the money borrowed from the creditor that was used to repay the creditor for the purpose of securing a loss in the hands of the debtor payee, it was nevertheless said to be a payment for the purposes of trying to get a deduction for yearly interest, because what that provision was looking at is whether or not there is a payment. There is a payment of interest, and if there is, then that satisfied the statutory requirement. And that's the passages that deal with that, my lord, are doubtless familiar to you. But if you'd like me to take you to those, or I can give them to you.
Can I just ask you, before we go there,
yes,
about paragraph 12 of Rossendale,
yes,
where the Supreme Court says another aspect of the Ramsey approach is that where a scheme aimed at avoiding tax involves a series of steps planned in advance, and I think everybody agrees that this is such a case, it is both permissible and necessary not just to consider the particular steps individually, but to consider the scheme as a whole. Isn't that a pretty clear instruction to look at the entirety of the scheme?
My lord, I'd say no. And the reason I'd say no is because if it is a matter of statutory construction, then it's the words of the relevant statute that are required. So if one is always going to take all the facts into account, one isn't actually taking into account the facts that are relevant for the purposes of the statute. So what this might be taken to mean, but clearly it doesn't, because it then goes on to develop what the court does mean in paragraphs 15 and 16, is that you can start from a position, well, okay, these steps they've all taken place together. Okay, so they're a unit, they're a commercial unity, but are they relevant for all purposes? So if, for instance, the question is there a trade being carried on, such as an ingenious, then of course you'd have to look at the entirety of the facts. to work out whether or not the receipts that were being received in that case were sufficient to amount to a trade. But where the question that is being asked is a much more limited question, such as in BMBF, for instance, to take a different example, which is there an allowance, is there a right to capital allowances under Section 24? Well, then the facts to take into account are relevant to Section 24. So is there a disbursement by the lessor? Is there an acquisition of the property in the thing that is acquired by the lessor? And has that disbursement been made wholly and exclusively for purposes of that the lessor's trade? Yes. Then the requirements, those are the facts to take into account in order to determine whether the requirements of Section 24.
So paragraph, the first couple of sentences, or first sentence of paragraph 12 of Rossendale is, you say, too prescriptive.
We say that it is setting out, one should read a judgment in its entirety.
Yes, of course.
And we say that Ramsey has been described in many ways. And what this is setting out is the process of analysis, which starts at the general and then becomes more and more clear as you go through. So while Ramsey was created, as it were, in the cauldron of tax avoidance era schemes, the approach is always one of applying the statute to the facts that are relevant to that statute. And that, we say, is where we get to when you look at Westmoreland and McNiven, when you look at BMBF, when you look, indeed, when you look at the provisions of this case. But we also say it's relevant when you consider the case, for instance, of Good. In Good, which is also in your bundle of authorities, I cited it for a slightly different proposition. But if I might just take you to Good, it's at tab 30 of your bundle. So the facts briefly put were that this was a film scheme, and it was conceded that the film scheme didn't work, the loss relief in year one didn't arise. And the question was whether the sums that arose within the scheme in years 2 to 7 of the scheme, which were called minimum annual payments, whether those were amounts that fell to be taxed as income from a non-film business. And so one of the arguments that was being put was, well, the income arises in the context of the whole scheme. So you look at the whole scheme, and if the whole scheme doesn't give rise to a loss, then nothing happens within the scheme. And the Court of Appeal in that case said, no, that's not the correct approach. And if I might just invite you to go to page 2822, the question there being considered is the taxpayer, being a scheme user.
Sorry, wait a minute, I'm lost. 2822.
Forgive me, 822.
822.
822 at the bottom of the page.
Yeah.
It's the section that starts just above paragraph 50.
Issue 1 entitlement.
Exactly.
Yes.
The question there being considered by the court was the scheme user someone receiving or entitled to the MAPS, the income? And one could, as the argument was being put, say, well, actually, all of these were prearranged schemes, and all the money was hypothecated to go within the arrangements to pay off certain debts and loan interest, and therefore this person didn't have any entitlement properly so understood. And it is that question that arose within 611 of Itoya that the court is considering. And if I might just invite you to go to paragraph 51 and 52, the UT said that the purpose of 611 was to subject income to income tax, any income from the non-trade film business. I agree. In Khan, which is another case that just preceded this, it was held that on a purpose of reading of identical words in a different provision of the legislation, the focus had to be on the particular transaction under which the distribution arose, and not on the connected transactions considered as a composite whole. The same applies here, and the focus must be on the transaction giving rise to the income in question. And then the analysis carries on. So in Good as well, and in Khan, what the court did, applying the approach of Westmoreland, McNiven, UBS, BMBF itself, was to ask itself, what is the statute asking? And then what facts are relevant to that statutory provision? And then to find whether those facts are made out so that the application of the statute to those facts means that the treatment set out in the statute applies. So the focus, we say, at all times is on the relevant statutory provision. What Ramsey is not, and we've been told time and again by the courts, my lords, that it's not an anti-avoidance provision. It's not there as an overlay over the statutory words. I can give you a few examples of where this is said, just to make good my point. For instance, if I could take you to Westmoreland itself, which is in the second bundle of authorities.
I think the same point is made in Rossendale, if I remember rightly.
It's made in Rossendale. It's also made in the Royal Bank of Canada in Lord Briggs's.
Yeah, so we're going to Westmoreland.
Yes, just a point at paragraph 20. Tab 20.
20.
Forgive me, my lord. I've given you an incorrect reference. Westmoreland is in the first bundle of authorities, behind tab 13. It starts at page 218, and the relevant paragraph 29 is at 232. Page 232, paragraph 29. My lord, I'm bound to say that this does not look to me like a principle of construction at all. There is ultimately only one question of construction, namely to ascertain what Parliament meant by using the language of the statute. All other principles of construction can be no more than guides which past judges put forward, some more helpful or insightful than others to assist the task of interpretation. But Mr. McCall's formulation looks like an overriding legal principle superimposed upon the whole of the revenue law without regard to the language or purpose of any particular provision. Save for the rebuttal, a possibility of rebuttal by language, which can be brought within its final parenthesis. This cannot be called a principle of construction, except in the sense of some paramount provision, subject to which everything else must be read, like section 2.2. But the courts have no constitutional authority to impose such an overlay upon the tax legislation, and, as I hope to demonstrate, they have not attempted to do so. That's one statement, very strongly, that there is no superimposable principle of anti-avoidance. It all flows from the language of the statute properly construed. And a similar point is made, I think, quite pithily in Royal Bank of Canada, if you would like to see it, my lord, but I think the point is made. It's Royal Bank of Canada, it's the tab 36 in the third bundle. It's in Lord Briggs's dissenting judgment. That was one in which a plea was made that Ramsey is not limited to only avoidance cases. It applies to all statutory provisions. But he did say, and so tab 36, it starts at page 1011. The relevant passage, my lord, is at 1041.
Yeah.
Paragraphs 125 and 126, and there are only two passages within 126 to which I would like to draw your particular attention, my lords. It's just between F and G, but as Rivera, permanent judge, made clear, the House of Lords emphatically confirmed in Barclay's Mercantile at paragraph 33. Do you have that, my lords? It's just between F and G.
Yeah.
That it involves no special principle limited to tax avoidance cases. On the contrary, the effect of Ramsey was to rescue tax law from being some island of literal interpretation and bring it within generally applicable principles. And then going to the last sentence, my lord, of that paragraph, it is not just some magic weapon with which to defeat tax avoidance. So there isn't a separate principle of Ramsey that is, it's all about tax avoidance and doing away with tax avoidance. That may be where it started, but the courts have over time developed that statutory principle so that it is a principle of statutory construction and no more. Which of course then begs the question, what is the statute? to which we are to apply this. And the relevant statutory provision is to be found, it's got 4 versions, but it's to be found in the first bundle of authorities. The reason I have set out all 4 versions is so that you can see the development of the legislation and to see the structure of the legislation and that the language remains consistent throughout. And then to overlay that with why it was produced and what was said about it and what changes happened, which nevertheless mean that Mr. Watts is entitled to his loss relief, loss from a discount on a strip in particular. So you have behind tab 1 of the bundle of authorities, Schedule 13 in its original form. And I'm going to just do a page turning exercise, if I may. So what paragraph 1 does is deal with the question of profits arising from relevant discounted securities. Where a person realises the profit from the discount on a relevant discounted security, he shall be charged income tax on that profit under case 3 of Schedule D, or where the profit arises from the security out of the United Kingdom under case 4 of that schedule. Sub 2, for the purposes of this schedule, a person realises the profit from the discount on a relevant discounted security where he transfers the security, and then B, the amount payable on the transfer or redemption exceeds the amount paid by the person in respect of his acquisition of the security. So that deals with profit. It identifies the type of profit it's talking about, which is a profit from the discount on a relevant discounted security. It then defines what is meant by a person realising a profit from the discount on the relevant discounted security in sub 2. And you can see, having read paragraph 14a already, my lords, that there is a similarity in structure. We then go to paragraph 2 immediately below it. Subject to the following provisions of this schedule, where a person sustains a loss in any year of assessment from the discount on a relevant discounted security, that person shall be entitled to relief from income tax on an amount of the claimant's income for that year equal to the amount of the loss. So that's all in 2 sub 1. And then 2 sub 2 over the page states, for the purposes of this schedule, a person sustains a loss from the discount on a relevant discounted security where A, he transfers such a security, we're not concerned with amounts on redemption, and then B, the amount paid by the person in respect of his acquisition of the security exceeds the amount payable on the transfer or redemption. And then 3 defines relevant discounted security. Now, you don't have, my lords, to concern yourself with what is meant by relevant discounted security, because if you go forward to PDF 11, page 11, you see a paragraph 14, sub 1. Every strip is a relevant discounted security for the purposes of this schedule. And then paragraph 15 over the page tells you what strip means. And you have, should you be so inclined, also got a tab 3, you do have paragraph, section 47 that is referred to there at tab 5 of this bundle, but I don't intend to take you to it. So what we have is a profit and loss, but the profit is profit from the discount on a relevant discounted security, loss from the discount on a relevant discounted security. The structure of those provisions is such that they identify that the loss so described and the profit so described and tell you how to arrive at them. So we see, you will note that paragraph 14 deals with gilt strips, but it does not provide for any loss relief particularly. So you don't have a 14a. That is because at this point, because a gilt strip is deemed to be a relevant discounted security, it would feed into the loss relief provisions in paragraph 2. So moving on to the next provision, which is the next version. And here we see, this is a PDF 13. This version was in place between 99 and 25th March 2002. You see that from the top of the page, my lord. Paragraph 1 similarly states, a person realises the profit, where a person realises the profit from the discount on relevant discounted security, he shall be charged income tax on that profit. And then sub 2 of paragraph 1 defines how that is to be arrived at. And we see a similar provision in paragraph 2, where a person sustains a loss in a year of assessment from the discount on a relevant discounted security, that person shall be entitled to loss relief.
This is the same wording, isn't it?
It's exactly the same wording, but what changes is paragraph 3.
Yeah.
They introduce new provisions into paragraph 3, which are aimed at dealing with particular anti-avoidance, or these are meant to be anti-avoidance in order to allow to leave out of account certain types of things from being relevant discounted securities. So you see that in 1A, 1B, 1C, 1D, 1E, 1F. So those have been added between the first and the second, but what that does not do is affect the application of paragraph 2, which is the loss relieving provision, to gilt strips, because paragraph 14.1 continues to apply. Paragraph 14.1 is to be seen at page 21.
Yeah.
So the position for gilt strips still gives rise to a computation of the loss arising from the relevant discounted security, because it's a deemed relevant discounted security at this point. And it tells you at 2 sub 2, as my lord rightly pointed out, how to compute the amount of that loss. And that loss is the amount paid by the person in respect of his acquisition of the security exceeds the amount payable on the transfer or redemption. And then over the page, over the tab, my lord, if we go to the version that was in play behind tab 3, which was in place in relation to the periods with which we are concerned, we see that paragraph 1 says the same as it did before. So this is PDF 24. So profits are still chargeable. You see 2 has been repealed. So you see that the entirety of the loss relieving provision, so loss from a discount on a strip, has been removed. But where does that leave the position of gilts and gilt strips? So if one goes to PDF 31, you see that paragraph 14.1 still applies. Every strip is a relevant discounted security for the purposes of this schedule. And then you see a new provision that is brought in, paragraph 14A. And that is the provision that states, a person who sustains a loss in any year of assessment from the discount on a strip shall be entitled to relief from income tax on the amount of the income for that year equal to the amount of the loss. So what you see is that paragraph 2, which is the general loss relieving provision for relevant discounted securities, has been removed. But loss relief from the discount on a strip has been expressly preserved as the target of relief by the introduction of a new provision, paragraph 14A. And if you cast your eyes over paragraph 14A, not only is the structure very similar to the structure of you have seen in the previous versions of paragraph 2, it contains no anti-avoidance language. So if paragraph 2, and I'll take you to the statement in Parliament that's explain why it was removed, but if paragraph 2 was removed because of anti-avoidance concerns, but paragraph 14A was introduced in exactly the same terms with no anti-avoidance provisions added in, save for one point, and I'll take you to that in a moment, we would say that the clear indication from the legislative history is whatever may have been the position in relation to the loss from a discount on a relevant discounted security more generally, Parliament wanted to preserve for gilt strips relief for losses from the discount on a strip. We say that because 1, it introduced a new paragraph 14A to deal specifically with gilt strips and losses on gilt strips. 2, the language of paragraph 14A mirrors the language of paragraph 2, which has been repealed. there hasn't been the introduction within paragraph 14A of anything that says if you do this for the purposes of avoiding tax, or you do this with the main benefit of getting a tax advantage, you don't get this relief. It doesn't have provisions like that in there. What it does have is a provision that that tells you that at sub 3, for the purposes of this paragraph, a person sustains a loss from the discount on a strip where, and we see the word where as not being including, as not being broader, it is prescriptive. So you see that the concept in sub 1A is a person who sustains a loss from the discount on a strip shall be entitled to relief from income tax. And then 3 defines that concept. A person sustains a loss from the discount on the strip where A, he transfers the strip, so that's the occasion for gauging whether or not there has been a loss from a discount on a strip. And 2, it quantifies the amount of the loss from the discount on a strip. So the amount paid by him for the strip exceeds the amount payable on the transfer. No account being taken of any costs incurred in connection with the transfer or redemption of the strip or its acquisition. So it tells you what you're not supposed to take into account as well. Now, why do we say that this is relevant? Well, we say this is relevant because you are given a formula by which to arrive at the amount of the loss from a discount on a strip. You are given the 2 things that you're supposed to take into account, being the amount paid for the relevant discounted security and the amount payable on the transfer. You're told what relationship they are to have with each other. It's a take one away from the other function. So, and that is the exceeds, so one exceeds the other. And then in the tail piece, you're told the loss shall be taken to be equal to the amount of the excess. And it tells you in what year it's to be said to be sustained. So I'm going to take you into the inputs in that in a moment, my lord. But the broad point that I'm seeking to make here is that paragraph 14A was created in order to preserve for losses for discounts on a strip, the relief.
And this applies whether you buy the strip direct from the government at one of its government auctions, or you just buy it in the market.
It doesn't seem to limit it, my lord. The language itself it's the amount paid by him for the strip. It looks no wider. It doesn't require any sort of further additional factors to be taken into account.
And amount paid means what?
We would say that it means exactly what it says, my lord. It is what has been paid by the person acquiring the strip.
So if I transfer gilts to you in return for the release of a debt, so no money actually changes hands, have you paid nothing for it?
Well, that would be, we would say that would not be what this piece of legislation is looking at. It is looking at what you have, what it is looking for is, has there been consideration paid by you or accepted by you in some way so that you have borne the burden of the cost of the acquisition? Because what it is looking for is to arrive at the amount of the loss from the discount on the strip. So it's looking at your acquisition cost, whether it's in cash or whether it's in kind, and it is looking for the disposal consideration. What have you received in relation to it?
So if I exchange your gilts for my constable painting, that will do.
It would be whatever the consideration that would be. It isn't intended, we would submit, to be anything more than a quantification mechanism. It's not, it doesn't matter how it is paid, it is the fact that it has been acquired for payment, whether in cash or kind. And the other part of the input is the amount payable on the transfer, and I'll come to that in a moment. But one point I did want to make, my lord, is if I could invite you to look at sub 4. In sub paragraph 3 above, the reference to a transfer includes a reference to a deemed transfer under 14.4. Now, what is the purpose of this, or what is this actually saying? So if I could take you both to the meaning of transfer and then to 14.4, that might assist. So page 27, paragraph 4. It defines transfer. So transfer is not just anything. Parliament has given some thought to what transfer means. And subject to subparagraph 2 in the schedule, references to a transfer in relation to a security are references to any transfer of the security by way of sale, exchange, gift, or otherwise. So it's identified 3 very specific, 1 non-specific, but that's what it calls a transfer. And then sub 3 and sub 4 talk about where you dispose of by virtue of an agreement, whether conditional or unconditional, and the timing of that transfer. So when you then apply that to paragraph 14.4, so bearing that meaning of transfer in mind, one goes to 14.4 because that is imported into 14a by 14a4. 14.4 says a person who holds a strip on the 5th of April in any year of assessment and who, apart from this subparagraph, does not transfer or redeem it on that day shall be deemed for the purposes of this schedule to have transferred the strip on that day, to have received in respect to the transfer an amount equal to the strip's market value on that day, and to have reacquired the strip on the next day on payment of an amount equal to the amount for which it is deemed to have been disposed of on the previous day. So there's a deemed disposal, reacquisition for a deemed consideration. The idea being, and this comes through in when one looks at the consultation documents, the idea is so in order to ensure that there is a triggering of gains or losses at the end of each tax year, so that there isn't a benefit hanging on to them beyond the end of the tax year. So there is a notional construct, we say, that is included within paragraph 14a. It isn't simply only looking at what may be said to be the loss on an actual transfer, the loss from a discount on a strip of an actual transfer of the strip, but also the loss from a discount on a strip on a deemed transfer.
Do we need to notice paragraph 4, subparagraph 3 and subparagraph 4? We have no relevance.
We would submit that they go to the idea, so this is part of the argument on used and generous. We would say that for present purposes, the meaning of, for all purposes, the meaning of transfer in this provision is to be found by 4. Sale, exchange, gift are 3 specific examples. They involve a passage of property, a change of ownership, a transfer of rights. And we say that consistent with that, the or otherwise should also be so understood. So it needs to be something that passes property, that passes an equitable interest or beneficial interest in the underlying assets. And 3 and 4 tell you what happens if you have a conditional contract and an unconditional contract for the transfer of that property. So beyond that, my lord, I don't think that 3 and 4 add very much. It is just to show that there is meant to be a transfer of some sort, a passage of ownership between A to B, in order for something to be a transfer so defined. So, what, having just before I come on to what on the transfer, payable on the transfer means, because that is obviously the input with which we're most concerned today. If I could just finish the final iteration to which I wish to take you, and that's in the next tab of the bundle. And this came into place following the period in which Mr. Watts entered into his arrangements. So you see that from...
Why is it relevant, therefore?
Because it introduced anti-avoidance provisions, and I don't want you to be concerned that I didn't take you to something that did after the event and not retrospectively produce some anti-avoidance provisions that related to paragraph 14a. So if you look at PDF 44 onwards, you will see 14a is set out in the same terms, but then you have 14b, c, etc. And they deal with particular sorts of arrangements that they were trying to stop. But these provisions did not take effect for the period in relation to Mr. Watts. And we see that from the notes at the end of PDF 53.
Can I just ask
Yes.
a trivial question, but nevertheless one that's puzzling me? In the index to the authorities bundle, the various versions that you've been taking us to are recorded. The second version is as at 27th July 99, third version, 10th July 2003, fourth version, this one, 22nd July 2004. But the dates that are actually to be found are all different. So when we look at the second version, it says from 15th February 1999. Then the third version from 27th March 2003, and then the last one from 17th of March 2004. So is there some magic about the dates that are in the index as opposed to the dates that we see on the printouts of the legislation?
My lord, I can only apologise. There is no magic to those in the index. The idea was to show you.
Does that mean that the dates in the index are wrong and misleading?
No, my lord. It's just to show you that these are. I cannot answer to why the 27th July 1999 date is used. But what I can say, it may be that that's the date of royal assent. But
then why would the printout say that it applies from 15th February 99?
My lord, I cannot take you any further on this, but I will, if I might just ask my learned junior to be considering that point, and I will come back to you once we've considered it.
Right. The version that we are principally concerned with is version 3.
Yes, my lord. Yes, my lord. And you may ask, and I'll deal with this very quickly. You may ask, why is it that these provisions were introduced at all? Why was there anything introduced to do with relevant discounted securities or gilt strips? The answer is that the government wanted to establish a market in gilt strips. You have the 2 consultation documents, and they are to be found in the third bundle of authorities, the tabs 37 and 38. And they explain that the government was interested in establishing a gilt strips market because there was a view that there was enough money in this. And in order to do so, they recognised that they needed to simplify the tax system, and this is the emanation of the simplification following the consultations that happened there. I don't think I need to take you to those in particularly. So then one comes to the meaning of, I've taken you through paragraphs 14a in broad terms. I have drawn out the fact that the language used is similar in structure to paragraphs 1 and 2. I have taken you through the fact that 14a is a relieving provision and identifies very clearly the target of the relief, which is the loss from a discount on strip. It is that concept, we say, that is the relevant fiscal concept, because that is the only thing that is then defined by the statute itself, by paragraph 14a.
Let's just repeat what you say the target is. The target is the loss
from the discount on a strip, and that is the statutory language, my lord. A person who sustains a loss from the discount on a strip, and then sub 3, a person sustains a loss from the discount on a strip where. So those 2 terms, we say, echo each other, and that is the relevant fiscal concept that is the target of the relief. So then one has to ask oneself, how is that defined? And we've shown.
Just before you go on, is it your submission that there's some relevance in the use of the word discount? I was thinking that our task was mainly to construe the words loss payable, loss due to the amount payable on transfer. You seem to be emphasising the word discount, and I was wondering if there's something you get out of that word.
My lord, thank you for the opportunity. The point is this, that it is, given that Parliament has identified and defined loss from the discount on a strip, it is the entirety of that concept that is the target of the relief. It isn't just loss, because if Parliament had just meant to define loss, it would have done so. It says, it identifies in 1, loss from a person who sustains a loss from a discount on a strip shall be entitled. So it is that concept that is then defined in sub 3. The reason why we say it's important is because it has a very specific and exhaustive definition, and that specific exhaustive definition is found in 3b, made up of the 2 inputs. The concern that we had now is that if one were to take the word loss alone out, of that. One, loss itself is not defined. The phrase loss from a discount on a strip is defined, but loss itself is not defined anywhere here. And then what part is played by the remaining words from the discount on a strip? What weight do they carry? We know that Parliament deliberately used that phrase or that formulation because that's how it has used that formulation throughout in Schedule 13 in relation to profits, in relation to losses from RDSs more generally. And so we say that it's a deliberate choice on the part of Parliament to define loss from a discount on a strip. If you were to then dissociate loss, then one starts thinking, well, perhaps there's a more wider concept at play here. And we said that there is no wider concept at play here because Parliament didn't define loss. It defined loss from a discount on a strip.
Given that loss is not defined, should it not be given its ordinary meaning?
We would say that loss does not need to be separately defined here because the loss is not the target of this relevant provision. What this provision is targeting is the loss from a discount on a strip. That is the relevant thing that is defined.
All strips are discounted, aren't they? Because otherwise no one would trade in them. So one's trading on the amount of the discount.
Yes, my lord.
And it goes up and down depending on rates of interest effectively.
Yes, my lord.
So the reason, arguably, why Parliament's used that phrase is that it's obvious that whether you make a profit or loss depends on the amount of a discount from time to time. But it's still ultimately talking about the loss, isn't it? That's what the relief is for, it's the amount of the loss on the discount on the strip.
My lord, exactly. But the point is that it's not loss in and of itself. It is loss from the discount on a strip, which is arrived at by the formulation set out in sub 3b. So it says where, meaning where these conditions are satisfied. There is a transfer of the strip and A minus B, which is the amount payable on the transfer exceeds the amount paid by him. I've taken you to you have my submissions, my lord, on why we say that the loss on its own is not the defined concept,
Yes.
because Parliament has not chosen that way of defining it. You have my submissions on why we say that the relevant concept is the entirety of that term. You have my submissions on why we say how Parliament has said that amount is to be arrived at.
Yeah. And
then it dictates that that amount is to be that amount of the excess is the amount of the loss that is the target of the relief.
Yes.
So this then brings us to the inputs about the meaning of transfer, because it needs to be the amount paid by him is, as my Lord Lewison, Justice Lewison asked, is the amount that is borne by him. It's the amount he's paid out or received in kind or whatever. But the amount payable needs to be an amount payable on the transfer. And transfer, I have taken you to, my lords, is defined at paragraph 4 with 3 specifics and 1 more general. Applying the aorist and generis rule, we say that the or otherwise needs to be defined in a similar way. It needs to be something that passes property, because a sale passes property for consideration, an exchange passes property for consideration in kind, and a gift passes property for no consideration. All 3 have one thing in common, which is the passage of property, whether it's beneficial interest or absolute interest. So, or otherwise, consistently with the application of the aorist and generis rule, means it must take the same sort of meaning, which is that something passes.
Well, doesn't it create an equitable interest in the subject matter of the option if you grant an option?
My lord, what it does, it passes no property in the subject matter of the option. What it does is it limits the ability of the grantor of the option to deal with the subject matter of the option pending the exercise. And that, my lord, so there are two cases, and I've put them in my skeleton argument. One case is George Wimpey, where it was taken as axiomatic that the option over land didn't pass any property in the land. And then you've got J. Sainsbury and O'Connor, which talks about where there was an option over shares as to 5% for the purposes of group relief. The question was whether, pending the exercise of the option, the 5% of the shares actually passed property, equitably or beneficially, from the grantor to the grantee, and it was held not. So it didn't do so. So the subject matter of the option doesn't transfer on the grant of the option. And the only point at which there is a transfer of the subject matter of the option is on the exercise of the option, because it's on the exercise that property passes to the exercise, the person, the grantee of the option, or the assignee of the option in this case. And so we say one has to focus on the amount payable on that transfer, because it is that transfer that we're supposed to look at. Now, why do I say it is that transfer we're supposed to look at? Because of the word on. Parliament has chosen the word on. It's a very limited scope provision. It's a very limited scope word, forgive me. It's not in connection with, it's not in relation to, it's not any of the wider words that one might find in parliamentary language. It is talked about on the transfer. And we know that Parliament is capable, even in this piece of legislation, of using wider words.
Sorry to interrupt you, but you're placing an awful lot of emphasis on a single rather short word. I'm just trying to understand what exactly you're getting out of the word on. I mean, let's start with a slightly ridiculous question, if you'll forgive me. It can't be physically on. Yes? We're not talking about stamps.
No, quite.
So it doesn't mean physically on. So, given it doesn't mean physically on, what in your submission is the limit on the word?
We would submit that on is referring to on the occasion of. That places the transaction and the time. It's not in connection with, it's not in relation to.
What if it's paid a day later, or indeed a day before?
It's if it is payable because of,
The exercise of the option says if this option is exercised, the option amount, the exercise amount, will be paid 7 days after the exercise.
but the obligation arises on the date of the exercise, so it's payable on that date.
Not if it says there is no obligation to pay.
It's payable, forgive me, my lord, I understand your point. The obligation to pay that amount arises on the occasion of the exercise. The fact that it is in fact paid a few days later or whenever it is later does not change the character of that obligation, which is that on the occasion of the exercise, that amount is payable. And we say that
So that's reading some words in, isn't it? To try to make sense of those sorts of cases.
my lord, I would submit that it isn't reading in as much as, say, the Upper Tribunal and the FTT did. On the transfer, we say, means precisely what it says on the tin. There is a transfer. What is the amount payable on that occasion? That's it.
What would you say to it being read as the amount payable for the transfer? Does it include that?
The concern with going into abstractions like that is one can end up very far from the statutory language. The test is, my lord, what is the limit of on? And is it wide enough to include transactions that do not include the transfer of the gilt strip? That is really what we're concerned with here. Because the Upper Tribunal and the FTT both considered on the transfer to be wide enough to include occasions on which and amounts payable on those occasions, that did not transfer, did not occasion the movement of ownership rights from Mr. Watts to anyone. So they have included within the amounts payable on the transfer, amount payable on assignment. And I will deal with why I say that isn't right. But they've included the amount payable on the assignment, but not the assignment of the gilt strips. It's the assignment of the option contract. And if you ask yourself, well, what is it that the option contract has done? On the back of George Wimpey and J. Sainsbury and O'Connor, all it has done is, pending exercise of the option, Mr. Watts has held on to the interest in, all the interest in the gilt strips. All he is prevented from doing is, pending the exercise of the option, disposing of them to anyone else. When the option is exercised, that is the occasion on which property passes from him, the interest passes from him in the gilt strips to someone else.
So can I return to the question about the meaning of the word on? So it's not talking about a physical relationship. And I think you were accepting in answer to my lord that it can't be talking about a purely temporal relationship. So if the relationship is neither physical nor temporal, what is it?
Purely temporal is not the same thing as not temporal, my lord. The relationship is, we say, closely circumscribed to being the occasion of the transfer. So on our facts, it would be the exercise of the option. The exercise of the option, if it did contain a clause such as you said, my lord, Justice Miles, where payment is to be, it's agreed that the exercise of the option will happen today, but the payment for that will happen 7 days or whatever days from now. The obligation to make that payment arises at the point of the exercise of the option, because that is the condition upon which the exercise of the option has occurred. It's on that occasion, it's tied to it.
So is that a submission that the criterion is temporal?
It's a criterion that that indicates that there is a relationship between the transfer and the amount payable, and it's a very tight relationship, which is occasion-based, not purely temporal.
So the meaning is causative.
Causative could be very broadly defined. So words in connection with, resulting from, in relation to, could also be said to be causative, but they are not the words that Parliament chose.
So I'm a little struggling to understand the sense you're giving the word causative. Because, I do apologise. So it's definitely not physical. There seems to be some element of temporality to it, but it's not purely temporal. There seems to be some element of causation to it, but it's not pure causation.
My
Seems
lord,
to be rather fuzzy.
my lord, I would submit that it isn't in the least fuzzy, and the reason it's not fuzzy is because it's actually very accurate and very precise. The target is the transfer. What is the amount payable on the happening of the transfer? The happening of the transfer is the exercise of the option. The amount payable can have, needs to have been brought about because of the exercise of the option, i.e. the transfer. The point at which that amount is paid, if the obligation has arisen on the occasion of the transfer, is less important, as long as it is referable to, but in a very tight sense, rather than in some, well, sine qua non sort of way. It wouldn't have happened but for. It's not that sort of point that on is seeking to make. It's a deliberate choice by Parliament to use that one word. So while one can dissect its meaning, what it is not saying is you take into account transactions and amounts payable on transactions that are in some way connected to the general arrangements to do with the gilt strips, but which are not, in fact, the transfer of the gilt strip. And the points that the case that I have in mind is the grant of the option and the assignment of the option, neither of which transfers property, causes a change of ownership in the subject matter of the option, because that at all times stays with Mr. Watts.
But you really, your submission comes to this, I think, This is one of those cases which Supreme Court authority recognises, where you are directed to look at a particular transaction, not at a wider scheme as a whole. The particular transaction identified by Parliament, the transfer, that has a recognised meaning in law, which means it transfers property, and that you can see that from its definition in paragraph 4 of the schedule. And what happens otherwise than on the occasion of transfer is therefore irrelevant to the tax consequences.
Yes, my lord. That is the submission.
Yeah.
That everything else is irrelevant.
Yeah.
So and I'll come to this. So, for instance, where the UT and the FTT both say it was necessary in order for Investec to get the gilt strips. Well, what they mean there is that had the grant of the option not occurred and the assignment of the option not occurred, then Investec could not have acquired the gilt strips. But that's not the test of on the transfer. And where does the question of necessity come in? Where is the required come in? Where is that in the statutory language? So the extraneous factors are being taken into account in order to bring into play figures that are not figures that are payable on the transfer of the gilt strip.
Yeah.
My lord, if I could just address you on Berry. So at the start of today, I had set out the paragraphs 51 and 52, the propositions that have been set out therein, and which have been followed by many cases since. And those, would it be worth your while, my lord, to have it in front of you?
Yeah.
So it's at tab 22 of the Bundle of Authorities.
You're going back to Berry, yeah?
We are going back to Berry, my lord, just to show, I fit my ground too. But also
Yeah.
because
In a sense, it doesn't really matter whether Berry is right or wrong. First of all, because it doesn't bind us, and secondly, because our task is to interpret the legislation.
my lord, I
And
entirely
whether
agree.
I was right or wrong in Berry doesn't really matter all that much.
Well, my lord,
I mean, don't be shy of saying I was wrong.
my lord, you're very gracious. I've
I've held myself to be wrong before now.
The point that I was trying to make is that Berry paragraph 51 and 52 have been taken to be, as it were, the statement of the purpose of the legislation, so that focus has generally then been only on the facts. Whereas what we would submit is that the purpose of the legislation, in the light of the legislative history to which I have taken you at some length, and the structure of the legislation, paragraph 49 in particular, the fact that it was a deliberate choice on the part of Parliament to introduce this relief in order and to preserve this relief despite they taking it away from certain other things, that it wasn't looking at a loss in a general sense, it was looking from the loss from a discount on a strip, because that is what they wanted to promote and they wanted to protect and encourage use of.
Yeah, well, I think the first error that you say I made in paragraph 52 was to say that this was not a case in which Parliament's used algebra. You say, well, actually it has. It may not have it has used 14A3, A and B.
Yes, my lord.
And those are the inputs into a formula. So that bit of Berry is wrong. Second, you say it hasn't used words which have a recognised commercial meaning. It's tied itself to the transfer.
Yes, my lord.
And therefore that bit's wrong. And therefore,
well,
the
I make 2
conclusion
points there.
that I reached in 52 is itself wrong because the building blocks are fragile.
Yes, my lord. You've put it very well indeed, if I may say so. What I would like to say, though, there are 2 aspects to the point about loss, the recognised meaning of loss. That is why I've emphasised that the structure of this legislation throughout has been not just to say profit or just to say loss. It's talked about a loss from a discount on a strip because it means every single one of those words to have meaning. And those words are then defined as a composite. And those, that is why you can't associate loss from that meaning to give it a separate meaning. And that, we say, is an error, quite apart from the the A minus B point, which in fact even the FTT and the UT sort of brushed to one side and said, well, clearly it's all about the inputs, and they have a world meaning, a commercial meaning, and they must mean everything that is required in order to. And we say no, that's wrong, because transfer has this very specific meaning, and they haven't engaged with that meaning. So, my lord, you have saved me an awful lot of difficulty in dealing with in Berry. As you say, it doesn't bind you here, but it did bind courts below. And what they said, what they concentrated on, having, as it were, banked the purpose in Berry, as identified in Berry, which is just looking at what the FTT said, and which is in effect reading out paragraph 14a sub 1 without reference to, we say, the important extra element of paragraph 14a sub 3. That tells you what the purpose of that particular piece of legislation is, not just 14a sub 1.
Yes.
Sorry, can I just understand this? You say the statutory, in order to find out the statutory purpose, you have to read it quite closely, including subparagraph 3, is that right?
Yes, my lord.
I'm just wondering what's left to the idea of the statutory purpose, because it seems as though you're saying you take your narrow reading of, if I can call it that, of subparagraph 3, which you've explained to us very clearly, and then you say that is the statutory purpose. The way it's put in paragraph 51 of Berry, which is the way that the FTT put it, is a bit broader, because it says the statutory purpose is to give relief where someone sustains a loss from the discount on the strip.
And that, my lord, echoes the words of paragraph 14a1. So they've done no more than just read 14a1. We say that's a limited reading of 14a1. So the purpose of this provision is to identify the target of the relief in very clear terms, and if you come within that target as identified, you get the relief that the provision is seeking to give you. And that this is not a misreading of the provision is, we say, made clear from the legislative history. The legislative history being that I've already told you that they brought in 14a to preserve for gilt strips a relief that they took away from relevant discounted securities completely. But they brought it in knowing that the relevant discounted securities loss relief provision was being used for tax avoidance purposes. Now, but they nevertheless didn't include any anti-avoidance provisions within paragraph 14a at all.
I'm just not sure what's left for the idea of purposive interpretation here.
The purpose, we say, is driven out by, is the result of, not as in drive out of the land or something, the application of the Ramsey principle to arrive at the purpose of this provision, we say, is from reading the words of the provision against the statutory background and the legislative history, all of which we say are consistent with it targeting for relief the things that it identifies.
So the counter-argument that the revenue puts forward is to say the purpose is to relieve real losses, not artificial losses. What do you say to that?
My lord, I'd say two things. One is that is not what paragraph 14a sub 1 and 3 say. They identify the loss from a discount on the strip by a formula, and that is by the use of the word where, that is the one formula. There is no overlay of real loss or economic loss. Loss isn't separately defined elsewhere. The second point is that this provision also deals with losses that are not real life losses, because it deals with deemed losses. It deals with the possibility of a deemed loss, maybe put it more clearly, because of 14 sub 4, which is imported into 14a sub 4, which is the end of year deemed disposal reacquisition at market value. And market value, as we know from paragraph 15, carries the section 272 TCGA meaning, which is open market value, making certain assumptions. So the target of 14a is the result, is at whatever is the sum that is arrived at as a result of applying the inputs in sub B of paragraph 3. And it's not only looking at, so the cry that it must only be for real and economic losses, we say, is is undermined by the fact that the provision itself countenances giving loss relief for the losses arising from a deemed transfer. And to superimpose, we say, a concept of avoidance or anti-avoidance is not only inconsistent with the legislative history, but also with the approach to statutory construction that we are asked to undertake by the various authorities.
Yes.
So I can deal, I think, with the second aspect, which is what are the facts we need to take into account for the purposes of 14A? Well, those are the inputs, the amount paid I've dealt with, and the amounts payable I have dealt with, unless you need me to address you on that point any further. The third is having identified the relevant facts and then applying them to the facts here. What is the answer? The answer is the amount paid is 1.5 million. The amount payable on the transfer of the gilt strips is the amount payable on the exercise of the option, which is 150,000 odd, and that drives out a loss figure, and that is the loss from the discount on the strip. That is because that is the excess. That is, it's because the words are mandatory. The loss shall be the excess.
Yes.
And then the fourth aspect is the Upper Tribunal's errors.
We've identified those.
I've identified some of those, my lord.
They
I
didn't,
don't know if I
they
need to do
didn't
it more.
concentrate on the relevant transaction.
They didn't concentrate on the relevant transaction. Their approach to inputs, that goes to the question of approach to inputs. They did not apply ears generis properly. In fact, they dismissed it, saying their approach, therefore, and this is at paragraphs 48 and 49 of their decision. I could deal with this quite quickly, my lord, if I may, trouble you to go to their decision. It's the core bundle 6. Tab 6, if I could take it, paragraphs 48 and 49, which are PDF 76. Our analysis, sorry, my lords, do you have the passages? Our analysis also disposes of the appellant's argument that paragraph 4 defines transfer by reference to a common feature of the 3 specified terms, sale, exchange, gift, and an heirs generis catch-all, namely or otherwise. Ms. Nathan submits that these words are all the means by which property is transferred, thus it is submitted that only a transaction, etc. So they set out my argument, and then 49. However, the grant and assignment of the option are simply 2 steps necessary, although insufficient, in a composite transaction, effecting a transfer of the entire interest in the gilts to Investec. The assignment of the option was a part of the transfer of the gilts under the scheme. On a realistic view, the grant and assignment of an option to purchase the gilt strips and the exercise of the option were all parts of the means by which the gilt strips were transferred from the appellant and eventually purchased or acquired by Investec. So when they then go on to necessity also in paragraphs 50 and 51, but what they don't do is engage fully with the concept of heirs generis and the meaning of transfer, because had they done so, they wouldn't have dismissed it quite so easily. The next...
I'll ask you a question, sorry, this is a slightly different point from the one you were just addressing, but on the facts, supposing that the transaction was a bit simpler and the taxpayer on day 1 buys the strips, on day 2 just grants an option straight to Investec, and that same day, in return for a price. Same day, Investec exercises the option, same day it all happens. And then the extra 150,000 is paid. Is your analysis still the same?
Yes, my lord, because the property doesn't pass in the gilt strips until the exercise of the option. The option, the grant of the option doesn't effect a transfer.
So the other steps involving the setting up of the trust, the grant by the trust of the option, the assignment of the option, in a sense they're all irrelevant to this argument. You say, just straightforward case, you own the stuff, you grant an option over it, it's immediately exercised, but the 2 sums are then paid. You say this, your analysis
It's only the one on the exercise of the option that's relevant, because that is the occasion on which property passes. If there were, I mean, it would depend on specific facts, but on your facts, my lord, if nothing, if it's a straightforward option, there is no additional right or anything passed other than just the grant of the option, then no property does pass in the underlying gilt strips. But there may be occasions where the transfer of the sum comes with, it has a sort of a side agreement or a contractual agreement, which does in fact pass some or give some beneficial interest in the exercise of the option to the grantee of the option. And that may be a different scenario, but that's not our scenario. So the fact that, and you very rightly, my lord, pinpoint the point that it's Investec that's doing the buying, it's Investec that's entered into it, it's Investec that's doing it all on the same day. But the principle, we say, it's got to be an amount payable on the transfer. The on the transfer where it binds you to that one thing.
I think it follows that you say that asking the question, how much has Investec paid to get this property, is not the right question.
My lord, that's right. That is not what the that is not what paragraph 14a is asking you to do. 14a's regard, as it were, rather like 24, the regard is on the position of the lesser. The gaze of this particular piece of statute is on the difference between those inputs. And what is the purpose of arriving at the inputs? To arrive at the amount of the loss for the person who's realised a loss from a discount on the strip. So what Investec has entered into and what Investec is doing is, as it were, by the by. What is relevant for the purposes of this amount is the amount it is payable on the transfer, because that is the only input. So the way that the arrangements are described is that Investec was always going to be the other bank that came along and made the transaction. It need not have been, as it happens, but that doesn't change the analysis of the statutory provisions. The gaze is on amount payable on the transfer. Who pays it, we would say, is not relevant.
So can I just explore the position of Investec for a moment?
Yes, my lord.
If we go back to paragraph 14a, subparagraph 3b, we're looking at a situation in which the amount paid by him for the strip exceeds the amount payable on the transfer.
Yes.
We put ourselves in Investec's shoes for the moment. Is the amount paid by Investec for the strip, does that include the amount Investec paid for the option? Or is it only the amount that was paid when the property in the strip was transferred to Investec? Because if the latter, they have way overpaid for this strip, and they're going to have underpaid rather for this strip, and they will have a huge tax liability if they ever come to sell it.
Well, my lord, the gaze of this particular statute is on the position of the person who's realised a loss on the strip, i.e. the person who acquired the gilt strips and disposed of the gilt strips. So it's not asking what the position of the person acquiring the gilt strips is.
No, I follow.
Theirs is an independent, as it were.
Well, I'm just
statutory
putting
question.
myself in the position of Investec. Investec, let us say, using round figures, overall pay 1.5 million for this strip. And of that, the bulk is paid on the grant of the option, and 150,000 is paid when the option is exercised. Investec then sell the strip for its market value, 1.5 million. They cannot, on this analysis, can they take into account what they paid for the option? They have to. They are going to make a profit in terms of 14a on the difference between what they paid when they exercise the option and what they get when they sell the strip.
So they might, if you were to apply 14a to them, they would be in a position of having underpaid, so the amount paid by them would not exceed the amount that they get on exercise of, so on their sale.
They'd be within paragraph 1.
They'd be within paragraph 1.
They'd have made a massive profit on it.
Yeah.
So they
Because
would
you're
then
looking
have to pay tax on the profit.
Exactly, man.
And it is a mirror image provision.
The idea is that losses from a discount on a strip get this relief, and and profits from discount on a strip are taxed under para 1.
But you'd think it would have to have the same meaning, so that
They're not drafted in the same language, exactly the same language, my lord. So if you were to look at paragraph 1, where, but may I just, the one thing I would say, my lord, is that if the aim is to go for tax symmetry, when interpreting paragraph 14a, we say that there is no basis for that within the language of 14a. Nor indeed is there any basis for that when one looks at the extra statutory materials, such as the conducts, the consultation documents, or the legislative history, because paragraph 1 remained exactly the same all the way through, and paragraph 2 changed, and paragraph 14a was introduced. So the idea of tax symmetry, if that is what is being sought to achieve by this line of discussion, is, we would say, a red herring. It's not what the legislation at 14a
No, I see what
is
you're
seeking
saying.
to do.
I mean, in effect, you're saying there is a difference in language between 14a(3)(b),
Yeah.
the amount paid by him for the strip, and the language in paragraph 1 subparagraph 2b, the amount paid by that person in respect of his acquisition, which could be
And
wider.
it's wider, it could be wider, in respect of is wider language, my lord.
Yeah.
And we say that there is, when Parliament has wanted to use wider language to incorporate
Yes,
wider
I've got
concepts, it's done so.
Yeah.
I'm so sorry, can I ask another question, since we're on that paragraph 14a through b?
Yes, my lord.
It doesn't say, does it, exceeds the amount payable to him on the transfer or redemption. So it doesn't have to be a case of it's not a case of looking at the amount payable to the taxpayer.
My lord, I gave that some thought, and my understanding, my interpretation of this provision, this part of the input, is that it's the amount, because the amount is payable on the occasion of the transfer, it is that amount that is taken into account. Who is going to be the recipient of it? Well, it's the person who's likely to be disposing of it. But if that amount is payable on the transfer, then that is the amount that's taken into account. So the to him may be implicit, but it may depend on the particular facts. But it needs to be payable on that occasion. So for instance, it wouldn't necessarily. It's always difficult to hypothesize, because it's so on the language, we would say that it is not expressly saying it has to be received by the person who has acquired the gilt strips, but because it has to be paid on the transfer, i.e. on the occasion on which property passes, we say it's implicit, that must be how it's to be read. Because what you're doing with this provision is to arrive at the amount of the loss from the discount in the strip in the hands of the person, and that person is the person who's realised the loss from the discount in the strip. It's not trying to do something wider than that.
But it doesn't tie it to that, because one could imagine a case where there's a transaction under which the strip is transferred, but the owner of the strip agrees that payment be made to a third party.
One might imagine that, my lord.
So it can't be tied just to a payment to him.
We would say the omission of the words opens the possibility for that. But we say that for our purposes, when one looks at, not just for our purposes, when one looks at what is contemplated here, it is the difference between what was acquired, the payment for acquisition, and the payment for disposal, and nothing else. The anti-avoidance approach, the fourth point, error on the part of the tribunal, that they looked to try and marry up.
Yeah.
And this is paragraphs for your note, my lord. It's 109 and 127. It's in effect an anti-avoidance test that they've tried to bring, and this is the Upper Tribunal. So paragraphs 109 at PDF 88 and 127 at 92. And we say that there is no warrant for that in the legislation, either in the language or in the legislative history. And we know that case law tells us that Ramsey is not itself an anti-avoidance provision. It all depends on the language of the statute. So 109 the point being made here is that nothing in the extra statutory material that I took them to, or the legislative history, stated or implied the concept of loss in paragraph 14a denoted an artificial loss devoid of real world transaction. The language of artificial loss devoid of real world transaction has savours of an anti-avoidance sort of approach, and we say that that's not warranted at all by the legislation. And in any event, 14a4, by incorporating 14.4 and the deemed disposal, does countenance an artificial disposal and acquisition and a deemed market value consideration. So that's wrong on its own terms. And then a similar point can be made in relation to paragraph 127.
Yeah.
And then the commercial legal dichotomy, the Upper Tribunal failed to note that the FTT's approach infected its analysis, because it kept trying to work out whether something was commercial and therefore real world versus legal and therefore allowed to be artificial. And that infects throughout the analysis. But the point is that the Upper Tribunal should not simply have referred to it as they would have preferred her not to have used that language. It actually did infect the analysis, and they should have held that was the case. If I may just double check with my junior if there's anything else that I need to cover. My lord, if I can be of any further assistance.
Mr. Kelly, do you want to add anything?
No, my lord.
Yes, Mr. Davey.
May it please your lordships, good afternoon. In responding to my learned friend's case, I will, if I may, make my submissions in three parts. First, I will briefly say a few words by way of introduction. Secondly, I will deal with ground one of the appeal. Thirdly, I will deal with ground two of the appeal. I envisage spending most of my time on ground one. I think that's where the meat of the case is. And indeed, it touches on items arising under ground two. So having done that, I envisage being shorter with ground two. I hope in doing this way I will cover everything that's been done in the course of this morning. Without further ado, I'll turn to the first of those three elements, a few introductory words. By his appeal, Mr. Watts invites this court to do the following. This is at paragraph 5 of the appellant's skeleton argument. Set aside the UT's decision, set aside the FTT's decision, uphold his claim for loss relief of 1.35 million odd, and order that the revenue pays his cost of his trip to the Court of Appeal and the Upper Tribunal. Now, I say that not every invitation should be placed on the mantelpiece and accepted, and this is one that should be politely declined. The reason for that can be stated shortly. Neither of the two grounds of appeal are good grounds. I say it's worth briefly recalling a little bit of the history of this matter to set today's hearing in context. The scheme in question was marketed to Mr. Watts more than 20 years ago, 2003, expressly as a form of tax avoidance. Supplemental bundle 131, 133, 139. The Grant Thornton marketing material for the strip referred to within the FTT's decision at 16 to 17 and in the supplemental bundle at 115 to 1.6 contrasted on the one hand the quotes economic loss of participation in the scheme, which was stated to be nil, and on the other hand the supposed, in inverted commas, tax loss, which was stated to be a substantial 6 or 7 figure sum depending on the particular inputs. Mr. Watts decided to go for it. He did this against the backdrop of classifying himself to Grant Thornton as, quotes, a very experienced investor, marking himself near the upper end of the experienced investor scale, 8 out of 10, within Grant Thornton's documentation, and also as adventurous as opposed to cautious or even balanced in investment attitude. That's supplemental bundle 148. Also against the backdrop of Grant Thornton stating from the outset that the scheme may face challenge, supplemental bundle 133. The problem from Mr. Watts's point of view was that having entered into the scheme's promoters' views of the merits of the scheme changed. And it had always involved risk. Now he was told it was unlikely to succeed. So in 2012, the scheme promoters, Grant Thornton, having taken further advice from Tax Council, advised Mr. Watts that the prospects of successfully upholding a gilt strip planning scheme such as the present was, quotes, low. Mr. Watts' witness statement at paragraph 107, supplemental bundle 102, and Grant Thornton's letter, supplemental bundle 363.
And this is all very interesting, but where does it go in terms of the grounds of appeal?
Well, where it goes is that Mr. Watts comes before your lordships essentially asserting and hoping that the post-implementation advice of the scheme's own promoters was wrong, that the on further reflection advice of the scheme's tax council was wrong, that the initial view of the revenue was wrong, that the on reflection review...
Well, he may be right about all that.
He may be right.
It's for us to decide.
He may be right. My point is that while tenacity is a virtue, it's not a principle of law, and I do say that his basis for coming before this court doesn't provide a reason for the court to uphold the grounds that are made. I'll move on to ground one.
Yeah.
So ground one concerns paragraph 14A3 of Schedule 13. Paragraph 14A3 is, of course, an element within paragraph 14A, and therefore, before turning to the specifics of ground one, I'm going to start by walking through paragraph 14A. I'm grateful to my learned friend for having done a good deal of the legwork there, but I'd nevertheless like to look at it afresh. Authorities bundle, tab 3, page 31. So paragraph 14A comprises 5 subparagraphs, and it's 1 and 3 that we're particularly interested in. So subsection 1, a person who sustains a loss in any year of assessment from the discount on the strip shall be entitled to relief from income tax on an amount of his income for that year equal to the amount of the loss. So there are a number of elements in play there. There is a reference to a person. Well, we have a person here, that's Mr. Watts. There's the word sustain. That's not defined under the legislation, but it's an ordinary English word. I submit that it's to be given its ordinary meaning. Before the FTT, I made reference to the OED definition of sustain, and the particular definition I referred to, which is in the authorities bundle at page 1170, if the court wants, is to undergo, suffer, or have to submit to something unpleasant or harmful as loss, hardship, damage, to suffer, e.g. a physical injury. To undergo, suffer, or have to submit to something unpleasant or harmful as loss, hardship, damage. And that's also referred to in the FTT's decision at 154 in the context of citing my submissions. So one needs a person, and that person needs to sustain something. What is the thing referred to that the person has to sustain? Well, the answer is a loss. 2 initial points to make here before moving on to 14A3. The first initial point is this, and your lordships may consider it to be self-evident, but I'll make it anyway. As a starting observation or hypothesis, I would suggest that given what I've said about the meaning of sustain, to undergo something unpleasant, the concept of loss in this context is unlikely to be something good. It's unlikely to be something non-negligible. Secondly, if that starting observation or hypothesis seems plausible, then it would, I suggest, be thoroughly consistent with the ordinary meaning of loss. Again, that observation too may seem self-evident. It's simply that when one speaks of a loss, one is generally speaking as a matter of ordinary language, usually referring to something non-negligible, something real, something usually negative or adverse. One might speak of a financial loss, one might speak of a personal loss. I'll obviously come on to say more on loss in the context of 14A3. But those are a couple of initial observations. Given my submission on what sustained means, its connotations, and the ordinary meaning of the word loss. We also have the term strip, so we're still within 14A1. Strip means a gilt strip. And more precisely, it's defined under paragraph 15.1 of the schedule, which itself refers to section 47 of the Finance Act 1942, which is in the bundle at page 55. Ultimately, strip means, if one works it through, in relation to any stock or bond, a security issued on behalf of the government, which is issued for the purpose of representing the right to or securing a payment corresponding to a payment of interest or principal remaining to be made under the stock or bond. That's what a strip is. And we have the phrase discount on a strip. The notion of a discount on a strip points one towards subsection 3, and referring to the situation where a transfer takes place and there's a mismatch between the amount originally paid and the amount payable on the transfer. That's what's said in subsection 3, and we'll come to that in a moment. And if a person has sustained a loss from a discount on a strip, then they shall be entitled to relief from income tax on an amount of his income for that year equal to the amount of the loss. That's the final words of 14A1. We then get subsection 2. The relief is due only if the person makes a claim before the end of 12 months from the 31st of January following that year. That's not in point, the claim was made in time. We then come to subsection 3, which relevantly provides that a person sustains a loss from a discount on a strip when he transfers the strip, and then B, and the amount paid by him for the strip exceeds the amount payable on transfer. The loss shall be taken to be equal to the amount of the excess and to be sustained in the year of assessment in which the transfer or redemption takes place. So one sees within 14.3a that one is looking for relevantly a transfer of a strip. He transfers the strip. And within 14a3b, there are two elements. There's element 1.
Just before we get into the elements, would you accept that this is tantamount to a definition of loss for these purposes?
Yes. Within 14a3b, relevantly, we have two elements. Element 1, the amount paid by him for the strip. And then element 2, the amount payable on the transfer. So the question which the legislation is asking is whether on the transfer of strip, what I've called element 1 exceeds what I've called element 2. And then we have the tail piece at the end of 14a3. The loss should be taken to be equal to the amount of the excess. So the word excess is echoing the word exceeds, 14a3b. And we have the word loss again here. It's the same word that we had in 14a3, before that in 14a1. As regards the word transfer, that appears in 14a3a and b, and paragraph 4 of the schedule is headed the meaning of transfer. That's at page 27 in the bundle. So we're told that in this schedule, references to a transfer in relation to a security are references to any transfer, such as security by way of sale, exchange, gift, or otherwise. Now, my learned friend makes submissions regarding the word transfer, and I'm going to respond to those in a few moments, if I may. But in short, my position is and will be that the legislation is providing a straightforward, inherently flexible, non-comprehensive broad definition of transfer. That's the view the FTT has taken on 2 occasions, para 167 sub 1 in the present case, and also Judge Greenbank in the case of Andrew at paragraph 121, Authorities Bundle 643, where he described paragraph 41 as providing a broad definition of a transfer. And then back within 14A, so if we turn back to page 31 and then over to page 32, we have 4, which refers to a deemed transfer, and then we have sub 5, which deals with the position in respect of non-resident trustees. That's not in point here. The trustee is based in Manchester, supplemental bundle 320. So that's a very quick canter through what the legislation says. And then in terms of ground 1 of the appellant's appeal, ground 1, just to remind the Lordships, is that the UT failed, well, Roman 1, it's got 2 elements. Roman 1, the UT failed to recognise that the FTT erred in impermissibly seeking to determine whether the loss from a discount on a strip and the formula for determining the amount had a commercial legal meaning. And then Roman 2, the UT erred further in interpreting the amount payable on the transfer in 1403B as including amounts paid on the grant of the option. Now I'm going to focus initially on the second of those 2 elements, if I may. The reason I'm going to do that is because it's that second element, the meaning of the amount payable on the transfer, which ultimately I say is the key point of
Once we've decided that, everything else falls into place, doesn't it?
I think that's right, my lord. So that's where I'm going to go now. And in line with what your lordship has just said, just the phrase "the amount payable on the transfer" is itself a constituent element in working out what loss from a discount on a strip means. So if we make progress on the amount payable on the transfer, and then that should provide elucidation as regards the meaning of a loss from a discount on a strip. So the charge is that the Upper Tribunal erred in interpreting the amount payable on the transfer as including amounts paid on the grant of the option. The basis for that charge is the Upper Tribunal should not have taken into account all steps necessary in practice in order to effect the acquisition of the gilt strip. That's a direct quote from the appellant's skeleton argument to paragraph 31B. UT shouldn't have taken into account, quotes, all steps necessary in practice in order to effect the acquisition of the gilt strip. In addressing this, there are various points to make. The first point, more an observation than an argument, but I'll make it anyway. Your Lordship's consideration of this ground will be the 4th occasion on which the Court or Tribunal has dealt with this argument. It was advanced before the FTT in this case and rejected, FTT 167. Before the Upper Tribunal in this case and rejected, UTD paragraph 40, and before the FTT in a case called Andrew, where it was rejected, Andrew 112 to 118. We'll be asking this court to reject it again. Beyond that, in determining whether the criticism is valid, I say what is required is the familiar 2-stage process, looking to ascertain whether 1, the relevant legislative provision construed purposefully, was 2, intended to apply to the transaction or state of affairs in question viewed realistically, to echo the language of Lord Nichols in BMBF at paragraph 32, Authorities Bundle, tab 19. And other places as well. So, as the first of those 2 stages, the question to ask is, what is the purpose of paragraph 14A? In my submission, to find the answer, one goes to the case of Berry. If we could turn that up, please. Authorities bundle, tab 22, page 467. I think that's the second bundle. In the FTT, the matter had been dealt with by Sir Stephen Oliver, President of the FTT, the tribunal member Menzies Conacher. The FTT had held that the purpose of paragraph 14a is to be derived from 14a1. And in the Upper Tribunal, Lord Justice Lewison agreed with what the FTT said. If we go to paragraph 51, page 484 in the bundle. I won't read it out. I think you all just have seen it recently, perhaps.
We've got what the FTT said at paragraph 33. That's what they said. And then I said they were right.
Correct, yes. FTT, what they said is at 33. Quite right, my lord. And then at 51 to 52, yes, as I have said, the FTT held that the purpose of paragraph 14a was the general proposition, and then subparagraph 1. In my judgment, the FTT was right to identify the purpose of the paragraph in that way. And then the Upper Tribunal goes on to say what it says in 52. So what is the purpose of 14a? Well, in circumstances where someone has sustained a loss by virtue of a discount on a strip, it's to entitle that person to relief from income tax according to the amount of the loss. And according to the Upper Tribunal, the loss in question is not notional but real. You can see those words within 52. The focus is real commercial outcomes. Now, my learned friend's position, as I understand it, is that this misses the point because it fails to recognise that the inputs, as it were, in determining whether one has a loss from the discount on the strip, are not simply at large, but are described and delimited by paragraph 14.3. But I say that criticism itself misses the point because it sets up a straw man. It's no part of my client's case, and no part of the correct construction of 14a3 to disregard the inputs, which 14a3 prescribes. And indeed, the Upper Tribunal in Berry was plainly aware of 14a3 and saying what it said at 51 to 52, not least because the Upper Tribunal had expressly set out 14a3 as part of the relevant legislation just a few paragraphs earlier, Berry at 23. Rather, the point is that the inputs must themselves be viewed realistically. This idea is neatly expressed in the judgment of Judge Greenbank sitting in the FTT in another gilt strip case that I've referred to, Andrew. I'd be grateful if we could go to that. Authorities bundle, tab 28, page 618. So within the same bundle as Berry.
Sorry, could you give me the reference again?
Page 618.
Yeah, I got it. Yeah, thank you.
And then within that, what we want is paragraph 83, which is at page 637. So here, this sits within a section headed the case law authorities, which begins earlier at paragraph 65. And at paragraph 83, Judge Greenbank is discussing what is to be derived from Berry. I'd be grateful if the court would read paragraph 83. Grateful. So that's what is said in Andrew, and if you'll note, that's a passage directly quoted by the Upper Tribunal in the present case at paragraph 106. For immediate purposes, it's paragraph 83.3 within Andrew, which I say is of particular relevance. If we pick up on the words there, once the inputs into the calculation have been determined, regard must be had to the reality of facts of the particular case in determining those inputs. It's therefore necessary to determine the amount paid by the taxpayer for the strip and the amount payable on the transfer in the context of the facts viewed realistically, bearing in mind that the purpose of the provision is that any loss should reflect the economic outcome. Now, I said a few moments ago that in dealing with this aspect of Malone and Friends' case, I wanted to work through the familiar two-stage process. One, construe the legislation purposively. Two, ascertain whether the legislation so construed is intended to apply to the transactional state of affairs viewed realistically. That's most of what I wanted to say in terms of the first of those two elements. I'm now going to move to the second, and in the course of doing that, I'll also say a bit more on the meaning of the phrase, the amount payable on the transfer. So the second stage of the process we're embarked upon is to ask, having construed the legislation purposively, and I say Berry gets it right in focusing on 14A1 for the purpose, whether the legislation is intended to apply to the transactional state of affairs viewed realistically. In Berry, the arrangements were analysed as a scheme. So too in Andrew, they were analysed as a scheme. And so too in the present case. And I say that's the right approach. In my submission, context is everything. And an analysis of the arrangements in the present case that does not recognise their inextricably linked nature would, in my submission, be fundamentally remiss. Rossendale at paragraph 12, first sentence, means exactly what it says. The word used is necessary. That's not my word, that's the Supreme Court's word, and it means what it says. The arrangements here were, after all, expressly marketed by Grant Thornton as a set of, quotes, tax planning arrangements, Supplemental Bundle 130, as a, quotes, proposal to be implemented, Supplemental Bundle 129.
We've got the finding of the tribunals below, haven't we, on this? But it was clearly a composite scheme as it's been described in the case.
You're absolutely right, Lord.
So they're all interlinked, and we can operate on the basis of that finding.
You're quite right. So it's right to approach this as a scheme. It's right as a matter of principle. It's also right as a matter of common sense, based on the reality of the facts here. And I do say it is worth recalling what Lord Wilberforce said in Ramsey, describing, as he did, familiar principles, where he referred to the context of a, quotes, a series or combination of transactions intended to operate as such, at 324A, and reminded everyone that the court is not, quotes, compelled to look at a document or a transaction in blinkers, isolated from any context to which it properly belongs. It can be seen that a document or transaction was intended to have effect as a part of a nexus or series of transactions, or as an ingredient of a wider transaction intended as a whole. There's nothing in the doctrine of previous legislation to prevent it being so regarded. Ramsey 324A. Now, if that's the right general approach, and if it's in principle applicable to the present case, and I say it is, what does it mean for the specifics of the particular scheme and for the conceptual scope of the phrase, the amount payable on the transfer, within 14A3? Your Lordships are aware of the Revenue's submission on this because it's the same submission that was made before the FTT and the UT, and is set out in paragraph 33 and 34 of our skeleton argument. The Revenue's submission is that viewing the present arrangement not in blinkers, but sitting within their proper context, involves viewing the amount payable on the transfer as comprising two elements. One, 0.347 million odd, moving from Investec to the trustee of the Timothy Watts Trust on the assignment of the option, and 150,400 moving from Investec to the appellant on the exercise of the option. As we put it in our original skeleton back before the FTT, and right. Just looking at my learned friend's skeleton rather than mine. A different submission on it. Yes, so really the pith of the case can be found on page 16 of our skeleton. This is quoting from our earlier skeleton argument. So we'll see paragraph 42, just above the first hole punch. Viewed realistically, £, that's the amount payable on the transfer, is not the 150,400 claimed by the appellant, which is merely the amount transferred by Investec to the appellant on the exercise of the option, but in addition the amount paid by Investec for the assignment of the option, 1347. Thus, £, equals 1497449, the sum of 150,400 and 1347849. This is because the total consideration paid by Investec to acquire the gilt strip was 1497. 150,000 paid to the appellant and the 1347 paid to the trustee. Thus, when the transaction is viewed realistically and with regard to its composite whole, the only proper conclusion is that the foregoing sum was the sum payable on the transfer.
So what do you say is the meaning of the word on?
So I say the meaning of the word on has to be understood within the context of the phrase itself. If one talks about something happening on the transfer, as a matter of ordinary language, use of ordinary English words, there is sufficient conceptual scope within that to go beyond merely the exact scintilla temporis of the particular transfer of the property right. I mean, one can get there via looking at the meaning of, I'm going to come on to this in a few moments, but I'll deal with it now. One can get there by looking at the meaning of transfer under the legislation. We're told...
Before we come to the meaning of the word transfer, can we stick with the question I've asked, which is the meaning of the word on? Would you accept that the revenues approach is tantamount to reading it as meaning for?
Well, I'm happy to accept that. What I would say is the meaning of the word on, read within the context, when we're talking about something being on the transfer, is perfectly capable, without doing any damage to the language, of being able to cater for more than one payment and more than one moment in time. There's absolutely no problem with that as a matter of ordinary use of English words. So I say there's no difficulty reading it as including
I'm
for.
not sure that's in dispute, because I don't think the appellant dispute. If you simply divide up the consideration into two payments, paid, let us say, on successive days, that would still be caught. But the argument here is a different one, because it's not that there's a simple dividing up into two payments paid on successive days, but the nature of the two transactions are different. So one comes back to, well, what does this word, slightly enigmatic word for on mean? And if it means for, then the obvious question is, well, why didn't Parliament use the word for?
Well, what I would say is we have a rich language. There are various terms of phrase that Parliament can use. It's always a question of the proper interpretation of them seen within their context. Here, the phraseology is payable on the transfer. And I say there is sufficient conceptual scope for it to cater with what happened here in the composite of what everyone agrees, in the context of what everyone agrees is a composite transaction, a set of arrangements. I mean, if one talks about, we know that transfer includes sale, for example, because that's part of the definition of transfer within paragraph 4. If someone asks what's payable on the sale of a property, I would say the natural interpretation of that is not how many pounds and pence did you pay at the moment of completion, because that's a totally unnatural way to interpret that. If you ask what was payable on the sale of property, you're asking what was paid in order to acquire it, and that might
Include the deposit.
might well include the deposit. It's not at all uncommon for payments in relation to property to take place in tranches. Now, Milena's friend's case has to be that, well, she can't deny that transfer includes sale because it's part of the statutory definition, so she has to be able to cope with the phraseology payable on the sale. And a case has to be that the legislation is not sufficiently robust, cannot be properly interpreted to cater for the fact that you might have the sale of property with payments made in tranches. But I say manifestly that can't be right. That would be an extraordinary way to read those words. If I ask what was payable on the sale of a house, I'm not saying at 3 p.m. on the day that you got the keys, how much money transferred. That's not a question I'm asking. So that was the submission I made before the FTT. The FTT accepted it as FTT 166 to 167.
Well, sorry, I interrupted you at the point where you were going to refer, I think, to the definition of transfer. Or maybe you're going to come to this later. But of course, that's the other element in this, the statutory analysis. There's first of all the word on, is the definition of the word transfer, and in particular words or otherwise in that definition.
Yes, if your lordship would bear with me, I think I will cover precisely what
Yes,
your lordship would wish me to.
Don't let me take you out of your course.
So we've got the submission that was made, and the FTT accepted it at 166 to 167. And the UT accepted it at 38 to 40. I'd be grateful if we could have a look at 38 to 40. So we want core bundle.
This is the UT.
This is the Upper Tribunal. Core bundle, tab 6. So it starts at page 63. And the key paragraphs are paragraphs 38 to 40, so internal page 74.
Yes.
And I'd just be grateful if the court would read or remind themselves of
Yeah.
what is said at 38 to 40.
Yes.
So that's where the Upper Tribunal and the FTT landed. Why does the appellant contend that they were wrong to do so? Well, the appellant's main point, as I've already referred to, seems to be that in construing the relevant legislation, the Upper Tribunal should not have taken into account, quotes, all steps necessary in practice in order to effect the acquisition of the gilt strip. Appellant's skeleton argument, paragraph 13.b. I've got 3 submissions to make about that. First, on the face of things, I do say it's not an attractive submission if we are, and I say we are, in the realms of construing legislation purposively and viewing facts realistically and recognising that tax usually operates in the real world rather than that of make-believe. it will of course Ramsey at 326D, then the proposition that the court should be wary of a construction which is practical, I say, is itself one which should be treated with a degree of caution. Secondly, the case that is cited in support is the case of George Wimpey. And I say that doesn't advance the analysis. What George Wimpey is authority for is that an option to purchase is itself property for the purposes of Section 54 of the Stamp Act 1891. That doesn't shed light on this case. It's looking at a different issue in respect to different legislation. Thirdly, as to the contention that the statutory language necessarily would have been different had it been Parliament's intent to spread the conceptual net in a way which brought into account the sums paid on the grant or the assignment of the option, as well as on the exercise. I say that's not correct. And I think really I'm returning to the exchange I had with my Lord Justice Arnold a few moments ago. My submission is simply that the breadth of the phrase, the amount paid on the transfer, including its constituent elements, is in the first instance to be analysed having regard to its meaning and use as a matter of ordinary language. And as a function of how those ordinary English words fit together and are used, I say there's no difficulty with recognising that there is sufficient conceptual breadth to be able to cater for more than one sum of money, spanning more than one particular scintilla temporis.
But the argument is you focus on the moment when the property passes.
That is the argument. I say it's a bad argument for the reason I've already given. My Lord Justice Miles was stress testing the point with whether or what happens if the payment's at a slightly different time. And I think the answer was, well, maybe there's a little bit of leeway, but can't be too much. I say we know that transfer has to include sale. An absolutely typical example of a sale is one in which money is paid over in separate tranches. So there's no difficulty. It'd be odd if we had to be straitjacketed reading on the transfer in this terribly limited way. I said there's no ground for that, either in the way we use English language normally, or having regard to the definition in Section 4. It would also be contrary to the way it's been expressed in the higher courts on a number of occasions. One case which Lordships may be familiar with is the Scottish Provident case, House of Lords case. That was a case concerning cross options to buy gilts. And it raised the question of whether one party with an option to buy gilts had, in the language of the legislation, an entitlement to gilts. This was dealt with by Lord Nichols at paragraph 19, and perhaps I could take the court to 19, and then that may be a convenient moment.
That clock is fast.
Ah, okay.
It's about 5 minutes fast.
I'm happy to keep going for as long as the Lordships can bear it.
So where are we going?
The case of Scottish Provident, so what we want is authorities bundle, tab 20, so that's going to be bundle 2, page 440. Yeah, so the case itself begins at 430, and the particular paragraph that I'm interested in is paragraph 19, which is at 440. As I said, the particular issue there was whether one party had an entitlement to gilts. And Lord Nichols said this: that depends upon what the statute means by entitlement. If one confines one's attention to the Citibank option, it certainly gave Citibank an entitlement by exercise of the option to the delivery of gilts. On the other hand, if the option formed part of a larger scheme by which Citibank's rights to the gilts were bound to be cancelled by SPI's right to the same gilts, then it could be said that in a practical sense Citibank had no entitlement to gilts. Since the decision, Ramsey, it's been accepted that the language of a taxing statute, and these are the key words, will often have to be given a wide practical meaning of this sort, which allows and indeed requires the court to have regard to the whole of a series of transactions which are intended to have a commercial unity. So, just to recap, I say as a matter of ordinary language, there is no difficulty with recognising the conceptual breadth of the phrase on the transfer or payable on the transfer. That's the first point. Second point, as a matter of statutory definition, that initial instinctive ordinary language approach is fortified when one factors in that it has to include a sale. And thirdly, it's also fortified by the approach which has been articulated at the highest level in cases such as SPI. I think that is essentially all I wanted to say on that point. I can go to paragraph 4 if your lordships would like to look at it further, the definition of transfer. But I think I've made my basic
I've got
point on
two
it.
questions, if I may. I don't need an answer now. You may want to give me an answer at 2 o'clock.
Yeah.
The first is, should we pay any attention to paragraph 4, subparagraphs 3 and 4, especially since subparagraph 4 deals with what happens on the exercise of an option? And the second question relates to 14A, paragraph, the end of paragraph 14A3. Now, we know on the facts of this case, everything happened between October and November 2023. Suppose that the option had been exercised in the following year of assessment. When would the loss, if any, have been sustained?
Lord, I've made note of both of those, and if it's okay with the court, I'll come back.
All right, we'll stop there and start again at 2 o'clock.
All right, if able.